Hello, everyone, and welcome to this month's webinar, Navigating New Employment Laws, a 2024 update. This free webinar is available exclusively for our customers enrolled in our subscription services. I'm Stephanie Blicki, the Subscriptions Program Manager for Personnel Concepts. Today's webinar will discuss important new and updated federal and state employment laws effective in late 2023, and early 2024. And after a brief discussion, you can consult with our guest attorney on these key laws in our live Q&A session. So as briefly mentioned, today's agenda provides an overview of the various legislative actions and employment law initiatives that will impact most U.S. employers in 2024. So we'll start by examining newly enacted leaves of absence and paid sick leave laws. Next, we'll discuss the most pressing wage and hour updates impacting workplaces this year, including a proposed update to the federal overtime exemptions rule, a very recent final rule on independent contractor designations, and the passage of an updated joint employer rule. Then our guest attorney will also examine recent harassment, discrimination, and retaliation bills, including the Supreme Court ruling on religious accommodations. And then following that, we'll briefly look at major law enactments in California and New York, while also discussing some local, state, and federal minimum wage increases. And then lastly, we'll look at the most at a recent workplace safety updates enforced by the Occupational Safety and Health Administration, or OSHA, involving new reporting standards for high-risk industries. And in our final moments of the webinar, our guest attorney will accept questions and answer them live, providing Personnel Concept customers with the invaluable experience of engaging with a knowledgeable attorney on critical issues. Our speaker will also offer some key takeaways from today's session, and throughout we'll just be engaging our audience with some poll questions. So speaking of engagement, let's just get started with our first poll. Today's webinar session is heavily dependent on audience participation. And to make the best use of our time, we're searching for timely and meaningful employment-related questions to present to our guest attorney. So to ensure we're prepared to fulfill today's hour with helpful content, we need to know, what are you most interested in hearing about today? Is it leave of absence and paid sick leave laws, wage and hour updates, harassment, discrimination, and retaliation laws, or workplace safety law updates? And you can go ahead and select all that apply, or what's most relevant for you, and we'll do our best to focus on those. So let's get everyone a moment to get that poll in. Okay, we'll go ahead and close the poll, and then we're going to put the results here. So it looks like we're most interested in leave of absence and paid sick leave laws, followed by wage and hour updates. So we'll just make sure to touch on those for our audience. Thank you for your participation. And as your Q&A session moderator, I'll direct your questions to our guest attorney. Just keep in mind they might be slightly modified just to ensure the best outcome of the session. The purpose of this webinar is to provide accurate and authoritative information on the subject matter being discussed. It does not constitute legal advice. The applicability of the tips and laws discussed today may depend on your state, type of business, and number of employees. We recommend working directly with legal counsel and your human resource professionals on specific matters pertaining to your business. Personnel Concepts, our webinar hosts, our guest attorney are not liable for any errors, omissions, or changes in law or advice that lead to unfavorable outcomes. All right, so with all that, I'd like to welcome Attorney Jeffrey Fuji, our featured guest speaker. Jeff is an experienced labor and employment law attorney and has appeared frequently with Personnel Concepts as a guest speaker at our webinars. He's a graduate of Vermont Law School with a dual master's degree in JD and serves as in-house legal counsel to a diverse group of corporate clients. Jeff provides counsel on matters including labor disputes, employment negotiations, anti-discrimination, work policies, equity agreements, non-disclosure agreements, and of course, general consultation. Welcome, Jeff.
Thank you, Stephanie. Thank you for having me and for the introduction today. As you said, I'm a labor and employment law attorney focused specifically in those areas most of the time, and I've worked closely with business partners and internally human resources department teams on various employment law matters as they come up. Throughout 2023, employers of all sizes may have heard about new and updated federal and state labor and employment laws that took shape. Many of those laws took effect in late 2023, and some of them are taking effect right now in early 2024. Broadly speaking, employers are seeing changes in the subjects of leave policies, harassment policies, religious and disability accommodations, job posting practices, wage and hour, restrictions in employee contracts, and organized labor. Where new laws are in play, there is also expected to be a rise in employment litigation. Today's most important takeaway from all the changes we will discuss is that it is highly advisable, in fact critical, and will save employers money in the long run if each employer takes a chance to review the existing policies they have to ensure compliance with the latest laws.
All right, thank you, Jeff. We're definitely looking forward to discussing these topics with you. And before we proceed, we just want to ensure everyone can hear and see Jeff clearly. If you have any audio issues, just check the volume on your computer or mobile device. If it doesn't solve the problem, let us know in the chat and we'll work to improve the audio as best we can. And before we begin, Personnel Concepts is offering our attendees our 2024 New Year, New Laws white paper, along with today's slide presentation equipped for note taking, which is attached here in GoToWebinar. So if you have any issues downloading those, please let our staff know in the comments. And at the end of the session, you'll receive a downloadable certificate via email as proof of your attendance today. Also, I just want to invite everyone in attendance to submit any questions you may have during the presentation using that Ask Question feature and GoToWebinar. You can also just pose them in the chat window. So most of the questions will be saved for the end of the presentation, but if they're relevant, we'll pose them more appropriate. So with that, let's just get started with today's presentation. So Jeff, in recent months and years, there's been no shortage of employment law updates in the US. And before we get into specific laws that affect our customers, could you just give us a brief overview of some of the critical law changes that occurred through 2023?
Sure, Stephanie, I'd be happy to. In early 2023, the Federal Speak Out Act went into effect, prohibiting courts from enforcing non-disclosure clauses if an employee signed the agreement with the clause inside of it before a dispute was initiated that alleged sexual assault or sexual harassment under any federal, state, local, or tribal laws. Similarly, non-disparagement clauses seeking to stop an employee from making a negative statement about their employer can no longer be enforced if the agreement was entered into before an instance of workplace sexual harassment or sexual assault occurred. Continuing on the same subject of employment contracts, 2023 marked the first full year for the Supreme Court's ruling to take effect. And this ruling held that employers could no longer enforce provisions of employment contracts when those provisions forced employees to arbitrate rather than litigate certain types of claims. And one of these claims that have been banned from arbitration are claims related to speaking out on behalf of other employees, sometimes known as whistleblower claims. They can no longer enforce forced arbitration if it says that they have to do that for claims and they're related to that. That was a sort of a mentality that went on in the court level, that those were important rights to advocate for fellow employees that shouldn't be denied. In August, the U.S. Citizenship and Immigration Services, or USCIS, released a new version of the Employment Eligibility Verification Form, or the I-9 form, and many employers are probably familiar with that. Their HR departments probably manage that process for them. The latest version became the new default form that employers needed to begin using back November 1st of 2023. In this new form, USCIS made significant changes to both its language and its instructions, including a checkbox indicating that an employee's Form I-9 documentation could now be examined using alternative procedures, including procedures over the web and video conferencing. The Department of Homeland Security recently authorized those changes, and a lot of them followed COVID, where it wasn't necessarily practical anymore for employers to be having employees come into the office, go to a person in a centralized location with a little baggie of documents they used to bring to protect them from the rain and the elements, and have that person look at those. In the modern context, a lot of employers are switched over to a remote setting, and they have employees all over the place, and to get them to physically bring in documents and also to get them to give up those documents, those are impractical and inefficient. So the federal government caught up, they changed their regulations, and now the I-9 form, which is available online, allows for digital video and remote assessment of those documents as well. Now, knowing which form to use is important. Personnel Concepts is great at organizing forms and gathering information and their posters and also their direction to the right forms, and they can link you to the most up-to-date I-9 form. It's always important when dealing with federal forms or state forms to have the most up-to-date version. The older versions tend to gather like old books on a shelf, if that metaphor still makes sense to anyone, and they tend to sit there, and sometimes when you go online you might find the wrong one. So make sure you have the latest one. It was effective November 1st, 2023, and that's for I-9 verification, allowing for remote and video technology as well. Now, going back to October of 2023, 2 federal agencies announced that they were joining forces to fortify whistleblower protections in workplaces. The agencies were the Federal Department of Labor, you'll hear us sometimes today refer to them as the DOL, and the National Labor Relations Board, or the NLRB. Both agencies stated in their various news releases at the time that they would be collaborating to provide more information sharing, outreach, and training efforts related to workplace whistleblower protections. Both agencies expressed that they believe that this is crucial to safeguarding the rights of workers who become whistleblowers when they raise concerns about illegal activities in the workplace, or when questions come up about them raising concerns about retaliation against their coworkers. Also taking place in 2023, protections for breastfeeding mothers in workplaces were expanded under the federal Providing Urgent Maternal Protections for Nursing Mothers Act, or the PUMP Act. This new law expands previous lactation accommodations for nursing mothers under the Fair Labor Standards Act. That's a federal law you'll hear us reference a lot today, is the FLSA. Exempt and non-exempt employees are now granted the same protections instead of being accessible to two different sets of protections. Employers must also provide a place other than a bathroom that is shielded from view and free from intrusion from coworkers so that mothers can lactate. Certain small employers, however, are outside of the coverage of the PUMP Act, and that could be true on a case-by-case basis with a lot of federal laws. So it's recommended that all employers contact their legal representatives to see if they are an employer who must follow the PUMP Act. Finally, it's no secret in 2023 that there was a high volume and a lot of high-profile strikes, including movements that have been taken on by the Writers Guild of America, the Screen Actors Guild America, the United Auto Workers, healthcares in the Kaiser Permanente system on the West Coast, educators in Massachusetts, fishermen in Alaska, and hotel workers in California. So a big cross-section of employees formed strikes last year and negotiated with their employers through their unions and their collective bargaining for different kinds of rights. Unions also formed for the first time with companies that had never seen them before, including in an Amazon facility in Staten Island, New York, and a Starbucks coffee shop up in Buffalo, New York. Overall, experts predict that organized labor is enjoying momentum at this moment, and that the success of the strikes in 2023 will lead to more union demands in the years ahead. These demands could include the mandate of higher workplace standards for non-unionized workers due to the spillover effect of union activities coupled with a competitive marketplace for talent.
Thank you for that clear overview, Jeff. And just for our attendees, we did link the updated Form I-9 in the chat there. So two topics that I think would affect many of our webinar attendees are leaves of absence and paid sick leave laws, which many of our poll answers for that. So are there any new laws effective in late 2023 or 2024 that employers should be aware of?
Yes, Stephanie, definitely. And I'm glad I was ready to talk about those today because the poll revealed that's what everybody really wants to hear about. Unless the legal question relates to a federally protected classification, changes to laws regarding leaves of absence and paid sick leaves often comes from state governments instead of federal governments. The most recent laws are no exception to this rule. It's worth noting that in the event of any updates to state laws, employers should re-examine their employee handbooks internally and look at their policies to guarantee that those employers are in compliance. For example of what we're talking about, let's go over to California. Beginning January 1st, California is requiring employers to provide at least 40 hours or 5 paid sick day for leave to most workers. This includes full-time, part-time, and temporary workers. Previously, the requirement had only been 3 days. California also recently expanded the state's Family Rights Act and Healthy Workplaces, Healthy Families Act to expand the categories of individuals for whom an employee can take leave to provide care. Employees can also designate any person to receive their care, provided that the individual is related by blood or a similar association to the employee that is the equivalent of a family relationship. The state also expanded its bereavement leave laws to allow employees to take up to 5 days for bereavement for a family member within 3 months of that person's passing. Employees may use vacation, personal leave, sick leave, or other compensatory time off if they want to be paid for the time they've taken with pay, and they can also choose to take that time without pay. Employers cannot interfere with the leave, except they have the one ability to ask for proof of documentation of the person's death that they're taking the leave for. Under California Senate Bill number 848, employees may also take leave time for reproductive losses beginning in January of 2024. And we'll clarify in a few minutes what a little bit of that is. We'll get into that a little bit more. In Illinois, the Family Bereavement Leave Act also expanded bereavement to require employers with 50 or more employees to offer up to 2 weeks of unpaid bereavement leave to mourn the passing of any covered family members. Workers can also take leave in Illinois for miscarriages, failed adoptions, and unsuccessful fertility procedures. And connecting back, those are the reproductive losses that I'd mentioned over in California. That's the category of what usually describes that. Illinois also passed the Paid Leave for All Workers Act, which as of January 1st of this year, requires employers to grant employees who've worked for at least 90 days a minimum of 40 hours of paid leave per year. Additionally, in Nevada, Assembly Bill number 163 expands protected leave in 2024 to cover victims of sexual assault. The bill also requires reasonable accommodations be provided for affected persons in the workplace. Tennessee, under its Senate Bill number 454, and Texas, under its House Bill number 1996, recently enacted legislation that requires insurance companies to provide coverage for lost income due to family leave.
Thanks for that insight, Jeff. Now, traditionally on an annual basis, federal, state, and local governments create or update a handful of regulations involving wage and hour laws. Is this past year any different?
You're absolutely right, Stephanie, and that's going on all over. Excuse me. And I think there's a couple of wage and hour-based developments that attendees might want to know about. At the federal level, in August of 2023, the DOL announced a proposed rule called the Defining and Delimiting the Exemptions for Executive, Administrative, Professional, Outside Sales, and Computer Employees Rule. Now, sometimes you see those very long titles, and sometimes they're designed to come up with a great acronym. Sometimes they're just a bunch of words. In this case, that's a very lengthy and long-worded rule because it applies to the various exemptions that have existed for the exemption of employees from the requirements to pay overtime. We've talked under the Fair Labor Standards Act about exempt and non-exempt workers. Non-exempt have to have overtime paid for the excess of 40 hours per week, and exempt do not. Traditionally, certain kinds of professional classifications, speaking very broadly, have been considered to be exempt. Traditionally, that was based upon salary and perhaps to some extent based upon description of job. Both of those things, salary and job description, have experienced a sliding scale in recent years where it's become more prevalent to see a higher salaried, perhaps traditionally considered more professional group of workers in the workplace. So what the federal government's doing, and what I'll explain a little bit more, is they're trying to build a scaling mechanism so that as these metrics continue to move upwards, more professional, more perhaps educated, certified, specialized workers, and also higher income, the considerations for what's exempt and non-exempt move as well. And the trend is towards more inclusion for more workers than perhaps less before. This rule is currently going through the rulemaking procedures under the American Administrative Procedure Act, and if passed, the new rule would update and revise regulations issued in conjunction with the Fair Labor Standards Act. Proposed revisions of the current regulations would increase the standard salary level and the highly compensated employee total annual compensation threshold, bringing more workers into non-exempt status, meaning they'd be covered by things like paid overtime and other sorts of labor protections and minimum wage protections. Since salaries tend to increase with inflation, and we know inflation is occurring, the DOL's proposed rule would also include a mechanism to automatically move the wage threshold in future years. The proposed changes would also ensure overtime pay for most low-paid salaried workers who earn less than $1,059 per week or $55,000 in a year. Finally, the proposed rule clarifies what workers fit the DOL's categories of executive, administrative, and professional employees, and what exactly are the criteria for those classifications that allow people to be considered exempt has been a popular legal debate that's gone on for many years with both the federal agencies and the Supreme Court at different points weighing in. As of now, these rule changes may not become effective until spring or summer of 2024, but employers can and should currently start to consider the suggested thresholds while looking at things like performance reviews, potential raises, bonus targets, and numbers.
Thanks for that information, Jeff. If that proposed law moves forward, it will definitely affect many small businesses and many of our webinar attendees today. So to assist employers in knowing the most recent minimum wage requirements for their state, we've attached a copy of the 2024 minimum wage map as a handout within GoToWebinar. So let us know if you have any questions on that. Now, Jeff, is there any other wage and hour related legislation employers should know about?
There is, Stephanie, and in fact, this next final rule was announced just last week. On January 9th, the DOL announced a final rule to help employers and workers better understand when a worker qualifies as an employee and when they may be considered instead an independent contractor under the Fair Labor Standards Act. The rule provides guidance on proper classification and seeks to combat employee misclassification, a serious problem that, according to the DOL, impacts workers' rights to minimum wage and overtime pay, facilitates wage theft in the workplace, allows some employers to allows certain employers in certain situations to undercut their law-abiding competitors and hurt the economy at large. In general, the final rule aligns with longstanding court precedent on which employers have previously relied on to determine a worker's status as either an employee or an independent contractor. This new independent contractor rule restores a multi-factor analysis the courts have been using for decades, ensuring that all relevant factors are analyzed to determine whether a worker is an employee or an independent contractor. The rule addresses 6 factors that guide the analysis of a worker's relationship with a company, including an opportunity for profit or loss that the worker might have, the financial stake and nature of any resources a worker has invested in the work, the degree of permanence of the work relationship, the degree of control an employer has over the person's work, whether the work the person does is essential to the employer's business, and a factor regarding the worker's independent skill and initiative. This rule separately rescinds the 2021 independent contractor rule, which became final under President Donald Trump's administration, that the department believes today is not consistent with the law and previous longstanding judicial precedent. This new rule takes effect March 11th, 2024.
Thanks, Jeff. That's definitely some timely information. It's also important to let our audience know that employers who partner with Personnel Concepts for compliance needs can be assured they'll receive these critical updates once they are released through our blog or via email.
Yeah, and that's great, Stephanie. And for the companies out there that are wondering, they can look to the various sorts of information that Personnel Concepts to provide when they're trying to conduct an in-house analysis of what their relationship with their workers are. I like to say as a starting point that we look at it as company and worker, or company and worker, and then we try to decide, is it really something we should call employer and employee, or company and independent contractor? And sometimes people get comfortable because the language in a contract they might have people sign says one thing or the other. But as the Supreme Court's factor test obviously shows in the rule to come, that's going to encapsulate that in a rule, they're looking at more than just the words. So the words employee, employer, or the words company, independent contractor, they may or may not define the relationship. And it's good to seek some professional guidance as far as an analysis of the specific situation. So we can move on to some other stuff too, just going back on that a little. In October of 2023, the National Labor Relations Board released another rule that's considered to be somewhat employee friendly, somewhat worker friendly, and this is called the Final Joint Employer Rule, and it rescinds a previous rule from 2020 that set a high threshold for designated when multiple companies working perhaps together under some sort of agreement, some sort of collaboration. It changes the situation for when those different companies can be considered a joint employer. Before, there were a lot of ways for companies to consider themselves separate from each other in this capacity and not necessarily a joint employer. Obviously, when you're a joint employer, that brings you under a lot of the labor law protections that we're discussing today. The practical effect is that previously a lot of these companies worked together and considered themselves separately in relation to the workers that worked for them. The new joint employer rule, however, follows recent employee-friendly decisions from the current NLRB board, and it's likely to bring many employers under the definition of joint employers as cases are brought before the NLRB for review and decision. Employers should review their contracts and their employment practices and policies to understand the potential implications of this joint employer rule, and this new standard that includes the concept of reserve versus indirect control and collective bargaining obligations. Another major theme in 2023 that's likely to continue into this year of 2024 is salary information required to be publicly disclosed when dealing with job postings. Since September 23, any business operating with 4 or more employees in New York State must comply with the state's new pay transparency law. Under this law, New York businesses must list compensation ranges for designated job postings, along with promotions and transfers. These ranges must include both the minimum and the maximum annual salary, or if the employment is hourly, the hourly compensation that's known by the employer when posting the job. Employers must also note whether a specific job is commission-based, and they cannot retaliate against employees who discuss salaries with other employees, even in the workplace. New York officials declared that the new law is part of an ongoing effort to address wage disparities, promote compensation transparency, and provide access to vital information to employees to enable them to make decisions about their own careers. As of January 1st, 2024, Hawaii also requires certain job listings to disclose hourly and salary rates. And if our listeners are wondering today, I don't know how many of them come from Hawaii, but if they're wondering why mention Hawaii in a presentation like this, we do that because it's important to note that where these laws occur in one state, you very often see similar trend patterns that emerge in other states. The progressive sort of moving forward very fast jurisdictions in terms of labor and employment law, they tend to be New York and California, but you'll see a lot of other states, like the states we've mentioned today, eventually following suit and doing similar things. One of those states, for example, is Illinois. And over in Illinois, on the topic of wage and hour, something is in place now called the Prevailing Wage Act, which creates a pathway for any laborer, worker, or mechanic who's employed by a contractor or subcontractor and paid for their services in a sum lower than the prevailing wage to bring a lawsuit seeking the difference of what they were paid versus what they should have been paid as damages. The law also went into effect right recently, January 1st, 2024.
All right, thanks again, Jeff. Let's take a slight break and just engage our audience in another poll question. These questions help us decide what we can bring you for more information via email or through our blog or other presentations. Based on the recent information that Jeff just discussed, which of the following topics would you like to learn more about in 2024? The Federal Speak Out Act, the Federal Pump Act, state-specific leaves of absence and paid sick leave laws, the proposed federal overtime exemption rule, the new final rule on worker classification. And you can select all that apply, and we'll give everyone a moment to get their polls in. Again, this just helps us kind of guide what information that we can bring back to you throughout the year. One more moment here to submit those polls. All right, and we'll go ahead and close that poll. And it looks like we're most interested in learning about state-specific leaves of absence and paid sick leave laws, as well as the proposed federal overtime exemption rule. So thanks for that information. We'll note that. All right, Jeff, earlier in the webinar, you mentioned that Federal Speak Out Act was enacted. That law prohibits courts from enforcing non-disclosure clauses if an employee signed them before an alleged sexual assault or sexual harassment dispute was initiated. Are there any other harassment, discrimination, or retaliation related bills that employers should look out for?
Yeah, it's a good callback, Stephanie. And there's a couple types of rules and rulings we should discuss. I'll say as we talk about this next topic, which may sound a little specific, everybody stay with me if you can and stay alert, because we're going to talk about this in the context of religious discrimination. But really, the ruling that we're going to discuss that came down from the Supreme Court in just a minute here, this really can be applied to almost any type of protected classification in the workplace in terms of how the Supreme Court has made this decision. And I would recommend that we can expect that based on this decision, in the case of Groff versus DeJoy that we're going to get into and explain a little bit, any other kind of protected classification you might experience in the workforce. So basically any of the Title VII protections, whether they be disability accommodation with the related ADA, religious-based accommodation, race, nationality discrimination, gender discrimination, all those things together. This trajectory that this case followed, we could see a lot more of this sort of application to those kinds of situations. So bear with me and imagine it if you can in the broad sense. I think that's a helpful way to look at it. A significant change occurred through the U.S. Supreme Court's ruling regarding workplace religious freedom accommodations. In June of 2023, the U.S. Supreme Court delivered an impactful employment law decision in a case called Groff versus DeJoy. This court case was based on the plaintiff's claim that he should be able to observe a Sunday Sabbath. His employer, the United States Postal Service, however, continued to assign him Sunday shifts. As a result, the employee missed 20 of those shifts, was disciplined, and felt forced to resign in 2019. That's important because feeling forced to resign can sometimes be called a constructive termination. The law might treat that as the same way as if he was actually fired. This employee claimed that the employer, the post office, had failed to accommodate his sincerely held religious belief, observance, or practice. Under Title VII of the Civil Rights Act of 1964, also just called Title VII for short, employers that have 15 or more employees must provide reasonable accommodations for an employee's sincerely held religious belief, observance, or practice, unless the accommodation would result in an undue burden or a significant hardship on the conduct of the employer's business. Up to the Groff decision, federal precedent had generally dictated that employers were required to provide such religious accommodations only if the burden to the employer was something called de minimis, meaning very small. The Postal Service believed they could count on this exemption, and they thought that they could have the employee work on Sundays because that created an undue burden because, among other things, it unfairly burdened other employees by requiring them to cover the shifts. But the court believed that the standard of undue burden under Title VII hadn't gone far enough, was inconsistent and inadequate, and should reach higher than it had, potentially requiring employers to incur substantial additional costs or substantial expenditures to accommodate an employee's religious freedoms. After the ruling, even somewhat expensive or inconvenient measures may be required to accommodate an employee's religious beliefs and most likely other protected classification-based protections in the future. The court also held in Groff that employers must consider other options that would accommodate the employee besides just the accommodation proposed by the employee. And for anybody who's aware of what their HR department has to go through in these types of situations, there's usually a discussion where the employee brings, in this case, their religious belief sincerely held to the HR department, or perhaps bring some other need for an accommodation. And what usually has been expected to happen is the HR department will say, well, what would you like us to do? What the Supreme Court has said is that what you would like us to do may not be enough, and employers should actually consider having a menu of options and solutions to present to the employee when the employee says, I have a need. So that is definitely a hiring of the standard from where it was before, and perhaps requiring employers to do more to meet the court's new ruling. On a case-by-case basis, the religious accommodations question is going to remain a fact-specific inquiry to determine what makes an accommodation an undue burden or an undue hardship for employers. The Groff decision overall, however, should be a warning sign to employers out there to tread carefully with religious beliefs, practices, and accommodation requests in the workplace. And that's broad because it includes any sincerely held belief, even if it's not attached to an organized, known religion, and also anything else that could relate to a protected classification under Title VII, or perhaps even broader back to the 14th Amendment, which is where Title VII comes from. Even if a workplace has less than 15 employees, some states and even some local governments enforce equal opportunity employment laws that mirror or exceed those of Title VII. These laws will sometimes affect workplaces that have as few as 2 employees. In California, retaliation against employees has to be carefully policed by employers starting January 1st, 2024, due to Senate Bill number 497. That law prohibits retaliation against an employee for a number of reasons, and also establishes that in addition to other remedies, an employer can be held liable for civil penalties assessed on a per employee by per employee basis for each and every violation of anti-retaliation laws. So an untrained workforce can become very expensive for an employer, because every employee who may violate a law with something like, for example, retaliation against an employee for whistleblowing, they could actually have to pay fines on that based on each individual employee who violates that. So you have to watch some of the aggregate bad actions that can occur when people get aggravated with one employee who stands up perhaps for something in the workplace that's protected. In other words, employers could be made to pay expensive civil fines for the conduct of each and every one of their employees who violate protected laws and retaliate against coworkers who engage in legally protected workplace actions, like, as we've discussed, the action of whistleblowing.
Okay, thanks, Jeff. And before we move on, I just wanted to encourage everyone in attendance to follow our blog at blog.personalconcepts.com for labor and law and news and updates. We'll put a link in the chat window so you can bookmark that. Jeff, you were discussing a new retaliation law in California. When creating employment laws, California and New York, like we talked about, they generally lead the charge in passing state and local legislation, and then many other states usually follow suit. Are there any important California and New York specific employment laws that employers in other areas may want to know?
Yes, Stephanie, that's a great point. Many states like California and New York the 2 states like California and New York will often be the lead, and other states will often follow. The reasoning behind that is perhaps a multitude of reasons, but the most obvious one is that probably the largest set of corporate offices and the largest actual labor forces exist in those 2 highly populated states. In the case of California, that might be obvious because it's the size of a whole coast. In the case of New York, it's more of a matter of tradition and concentration because of the very economy that exists in New York City as the arguable financial center. So California and New York have advanced more regulations and rules protecting employees. Largely because that's where the largest group of employees are. That's where people have the most lobbying for their legislators, who then control what the agencies do, and those agencies pass rules because of the mass population. California and New York will most likely to continue to make bold strides in those areas. Several bills enacted recently are worth noting for companies located in or doing business in these states, and more for everybody else for insight on the trends of labor and employment law. Here's a few things going on in California. Through California Assembly Bill number 489, the state established a new workers' compensation system to compensate employees for injuries sustained during employment. To comply, employers must pay into designated accounts that employees can draw on, using prepaid debit cards to access compensation funding. Also, California Assembly Bill number 520 expands the potential liability of public entities, be they something like a city, county, district, public authority, public agency, or any other political corporation or subdivision, for when they have unpaid wages to workers. Public entity employers can now be held jointly responsible with private entities for fines and penalties of non-payment of wages. And that's important to think about today as we talk about it, because you might also expect to see situations where public entities, they hire independent contractors. That could be something as simple as hiring a caterer for an event that's held by a public agency, to something perhaps more complex as hiring a construction company to build a building or a road. But what's going on with California Assembly Bill number 520 is the unpayment of wages to workers that are in those situations, including those subcontracted out situations, can lead to some real liability for the government and the private entity as well. So all affected employers on our side over here listening to the Personnel Concepts lecture should take a look at their policies to make sure that they're drafting all of their agreements in conformity with this law. California Assembly Bill number 594 empowers public prosecutors to prosecute civil or criminal actions for violation of specific provisions of the California Labor Code. It also requires any money recovered by the prosecutors under the Labor Code to go directly to the victims, the employees of these alleged violations. California Assembly Bill number 1076 renders non-competition clauses in employment agreements unlawful unless very specific exacting criteria are met. And this is what's sometimes called the assault or the attack on non-competition in California, which is a very real thing. The bill became effective January 1st, 2024, and requires employers to contact actively former employees and advise them of the void status of the non-compete clauses of agreements they'd signed. So for example, if those agreements contain provisions that stretch into the future and those provisions are now voided, the employers actually have to call up the old employees and say, just so you know, this doesn't apply anymore because of the new law. With this new power levied on prosecutors in the state of California, all affected employers need to re-examine their handbooks to make sure that they're up to date with all of these laws, as we said. Going back to this crackdown on non-compete specifically, employers are advised that they should consider the following actions to ensure they're complying with the non-compete crackdown. They should audit their employment agreements signed by both their current and their former employees and check that the non-compete provisions do not violate the latest California laws. They need to notify their current and their former employees that non-compliant non-compete clauses will become void by the date of February 14th, 2024. They should review their template employment agreements, their template offer letters, and their existing employment agreements that might risk any restraint on the free trade of the employees, so the ability of the employees to trade with their own labor, knowledge, and skill against perhaps the non-competition clauses that existed before. And they need to review other agreements, even beyond their employment agreements, to make sure that they don't restrain other parties outside of the employee from engaging in their chosen profession, trade, or business. And what that might look like is where, for example, a business signs on with another entity doing some sort of collaborative business, and they say, other entity, collaborator, colleague out there in an agreement with us, you can't hire our employee once they leave our company or from our company for a certain period of time, etc. That could be an issue because that would be a restriction on the employee by way of an agreement with a third party and to the relationship of the employee and the employer. So employers are also advised to look at those contracts to make sure they do an audit of their non-compete clauses and they see if those comply or do not comply with the current changed law. Let's talk about New York a little bit. New York State is also weakening the power of restrictive agreements. To do this, new laws in New York restrict the use of confidentiality clauses in certain employment-related releases unless the individual requests confidentiality themselves. The amendments further invalidate releases that require employees to pay liquidated damages for violating things like non-disclosure or non-disparagement clauses. Non-disparagement being you can't say anything bad about the employer and you can't write your tell-all book or go on the talk show and say, wow, they were terrible to me. Those are becoming invalidated. They prohibit employers from requiring employees to affirm that they were not subjected to any alleged discrimination or retaliation. So the gag order on those types of claims is going away. This new law, New York Senate Bill number 4516, took effect on November 17th, 2023, so it's already in effect now. New York State has also enhanced payment protections for freelance workers, which have increased exponentially during the COVID-19 pandemic and after, and this growth that's been going on for even longer, of something called the gig economy. When Senate Bill number 5026, aka the Freelance Isn't Free Act, takes full effect on March 13th, 2024, contracted compensation for any freelance worker must be paid on or before the date that's stated in the contract as a matter of state law.
Great. Thank you, Jeff, for that look at important new California and New York state laws. And as many employers know, at the beginning of the new year, some states, counties, and local municipalities even, especially in California, increased minimum wage rates for employees. As I understand it, Jeff, federal contractors are also scheduled to see a change in minimum wage rates. So before we begin our discussion about minimum wage increases, I just want to ask attendees another poll question, just to determine how much time we should spend on this topic. The question is, does your business utilize or employ federal contractors? Pretty straightforward, yes, no, or if you're not sure, you don't know, we can select that too. It kind of give us an idea of how much to cover or how quickly to go through this. We'll just give everyone a moment to submit their answers here on this quick poll. Okay, just another minute and we'll go ahead and just close this poll. Mostly no, a little bit yes, and a couple are unsure. So thank you for your responses. Now, Jeff, what minimum wage changes are occurring in 2024?
Oh, thank you, Stephanie. I appreciate the introduction to that topic that involves a lot of numbers and probably needs to involve a little bit more research, beyond just what I say today, working with personnel concepts or perhaps looking into what's changing on a state-by-state basis. I know you have that wage map that's very helpful. In 2023, the minimum wage for federal contractors was increased. Beginning January 1st, 2023, the minimum wage for federal contractors was set up to be adjusted upwards in each subsequent year to 2023. In 2023, the minimum pay for tipped employees working as federal contractors was required to equal 85% of the 2023 indexed wage. Starting January 1st, 2024, which is just passed, and for every succeeding year after that, the minimum pay for tipped employees must equal 100% of the indexed wage. With the exception of those contractors covered by a specific executive order, all workers who perform work on or in connection with federal contracts increased from a minimum wage of $16.20 per hour to $17.20 per hour beginning January 1st, 2024. This increase applies to most federal contractors who are working under contracts that were either entered into after or extended beyond the date of January 30th, 2022, so reaching back a bit. Under President Joseph Biden's executive order number 14026, a different methodology applies for tipped employees working on or in connection with federally covered contracts. For these employees, the minimum wage increased to 100% of the minimum wage for other workers, or $17.20 per hour beginning January 1st, 2024, and no longer allowing for tip credits. Interesting changes are occurring at the state level too. For example, in California, Senate Bill number 525 took effect on January 1st, 2024, establishing minimum wage schedules for covered healthcare employees. In Nevada, Assembly Bill number 259 requires providers of jobs and day training services to develop transition plans to assist people living with disabilities with reaching the state minimum wage. And in New York, the minimum wage has been increased from $15 to $16 in Manhattan, Nassau, Suffolk, and Westchester counties. And to those not from the area, and that's where I practice a lot of my law, but that's known outside of our areas, New York City and Long Island. And from $14.20 to $15, nothing small, for the rest of the state. In addition to the present increase, recent New York State labor law amendments provide for further increases of 50 cents per year beginning January 1st, 2025 and January 1st, 2026. The New York Commissioner of Labor has proposed regulations to amend existing wage orders to reflect these increases. The wage orders also include increases to the minimum weekly base salaries of those workers who are classified as exempt executive, administrative, and professional employees.
All right, thank you for that overview on the critical minimum wage updates. With the changes in minimum wages, most states and municipalities, and even sometimes specific industries or a mixture, they require a posting or distribution of an updated minimum wage poster. Just remember that Personnel Concepts is here to help with the poster compliance. So if you have any questions, you don't know if yours is up on the wall, anything like that, just get in touch with our compliance specialist today through our customer service line. We'll go ahead and post that in the chat as well. Jeff, are there any workplace safety issues employers must address going into 2024?
Yeah, that's an interesting question, Stephanie. I'd harken back a little bit to our conversation about I-9 because a lot of what's changed in the workplace involves sort of digital reporting. On July 17th, 2023, OSHA announced a final rule requiring electronic injury and illness reporting by specific employers in designated high hazard areas. The final rule affects injury and illness data that OSHA already requires these employers to keep. However, it adds a digital component. Meanwhile, OSHA also announced a national emphasis program focused on preventing common workplace hazards often found in warehouses, distribution centers, and certain high-risk retail establishments. These OSHA efforts followed the Bureau of Labor Statistics reporting in 2022, which revealed an increase in non-fatal workplace injuries and illnesses as reported by employers. There was also an increase, according to the Census of Fatal Injuries, released around the same time, involving fatalities in the workplace. The Bureau of Labor Statistics reported that spikes had been revealed as high as 7.5% compared to data gathered in the prior year in some of these areas. And this raised significant concerns with the workforce among federal agencies with jurisdiction over the workforce and the workplace. As such, all employers in high hazard and high risk industries should begin electronically reporting their injury and illness documentation to OSHA in this year of 2024, while continuing to follow OSHA standards and maintain safe workplaces. Individual states also undertook significant efforts in 2023 to promote and increase workplace safety through legislation and rulemaking. In California, for example, Assembly Bill number 752 requires the state's Department of Transportation to specify protective measures for workers in traffic work zones and then to compensate workers for purchase of safety devices that they go out and they do on their own. In Connecticut, House Bill number 6741 is aimed at a statewide initiative to develop a marketing campaign, monthly public service announcements, and social media content across the various social media channels to discourage violent behavior towards healthcare workers. And this became a major issue during COVID because of the mass influx of people in the medical setting and the variety of problems perhaps outside of physical health that they were bringing with them, mental health issues, criminality issues. A lot of people did not feel safe providing medical care to those who needed it. and protection of medical personnel and first responders is something that a lot of states are focusing on right now. Not just in the medical sector, but in all workplaces. We can look at New York for a good example of what's going on in terms of violence prevention in the workplace. New York's Public Employee Safety and Health Agency is aimed at protecting public workers, and they provide a how-to compliance guide that lists such guidance, developing and posting in a workplace written violence prevention statements, conducting a risk evaluation for violence internally, providing training and information to the employees and managers, documenting violence correctly, and annually reviewing incidents of violence, all of which is going on at the New York State level, yes, but this can be used by other employers throughout the country as a model to respond and to report on and to get ahead of workplace violence. More generally, back in California, Senate Bill number 553 imposes new obligations related to the prevention of workplace violence also. It requires employers to establish, implement, and maintain a workplace violence protection plan by July 1st, 2024, similar to existing injury and illness prevention plans that employers are already required to put together. It also requires employers to track and log workplace violence incidents, train employees on workplace violence prevention, and record logs of workplace violence incidents, trainings, and identification of new violence hazards. And this reporting issue is very important. This auditing issue is very important because I even had a California client this week that I was discussing this with, who may be listening perhaps, or who knows, but they could be out there. The whole idea is that they want to make sure that you're always doing an audit of your compliance measures. And sometimes that can be as simple as making sure there's a method in place for your managers and employees to report, making sure you gather those reports in a certain period of time, and then making a form for yourself that says, we audited these reports, we checked them, they revealed yes, a problem, or no, not a problem, and yes, we're responding this way, or no, we don't need to respond. And I would say that should really be done on a weekly basis. That type of reporting in things that states are mandating, like California and New York with workplace violence, that type of reporting can be used as an affirmative defense in the event that there's a lawsuit to show that the employer was not negligent because they were keeping up with active reporting requirements and compliance with the law. The alternative, failing to keep up those reporting requirements, can actually be proof of de facto negligence in a negligence claim. So when you have the laws in place and it says what to do, it's always great to try to follow the law to the letter. That can be used as a defense by employers if somebody raises a lawsuit later, and that will save them a lot of money if those claims come flying at them from an outside litigant. The law in California is also allowing for union leadership to get involved and to take action to prevent workplace violence towards their employees by way of seeking workplace violence restraining orders on the behalf of those employees. And that starts in January 1st, 2025.
Again, thank you, Jeff, for discussing recent and upcoming employment and labor laws. I want to remind everyone in the audience that our 2024 New Year, New Laws white paper is available as a download in today's presentation. Just features a list of all the enacted employment laws set to take effect in 2024. All right, so we've reached our Q&A session today. To participate in today's Q&A session, I just want to encourage everyone in attendance to submit the questions using that question feature and GoToWebinar. You can also ask our webinar staff in the chat window. We'll do our best to get through the most relevant audience questions throughout the session, but just know that all unanswered questions, or if it's something specific Jeff can't answer on the spot here, they will be sent to Jeff via email, and then we'll send all of the responses to all of our attendees today. So if your question doesn't get answered live, it will get answered. Take the opportunity. So with that, let's just take a look at our first question. We put up on the board here for reference. So let's get our first one. Can you please touch on the changes included within the new version of the Employment Eligibility Verification Form I-9?
Sure, no problem, Stephanie, and to the caller who had that question from the group. That's really a matter of reporting and using digital technology to record the process of I-9. The old I-9, for those of us that are old enough to remember it, I suppose, was a process where people would bring in documents, a passport, a birth certificate, a social security card, which I don't know where mine is, but maybe people know. It was something to take out maybe once a lifetime or a few times in a lifetime, bring it in, show it to a person in HR, and have them document that they've seen it, that it's a sufficient document, and then they check a box on a form. Well, as we know, there may not be somebody sitting at that HR desk in all instances. A lot of people outsource that function. There may not be a desk at all. A lot of people are now working remotely. So, and that could be true on either the employer or the employee side. So the federal government has caught up, and they've brought in a process now that working with Department of Homeland Security, DHS, allows for these actions that occurred before in person and live to occur remotely now. And so those documents can be verified through the new form with certain recordings and verifications of what occurred on a remote and digital basis. Reporting on that is important. The form walks you through the steps that are needed for that remote process to be verifiable and legitimate. But the form is also useful in providing guidance on what exactly you have to do. So this is a comfort to many employers because the remote workforce situation has, of course, changed many things. And sometimes there's a concern that the regulations haven't always caught up. This is a good example of the regulations catching up. And this is something that if employers follow, it should be able to give them some comfort.
Great, thanks, Jeff. And if you have another specific question on that, just go ahead and submit it and we can get it answered later. Let's put another one on the board here so we can get through some more. What is considered a small business? I think we have, maybe they're two separate questions, but we can start with that one. And we also have, do employers have to give 40 hours of sick leave to employees immediately after hire, or can it be after 90 days?
Yeah, that's a great question. And generally speaking, what's considered a small business is not always necessarily a legal term. That's more of a colloquial term. And the size of a business and whether or not the business is subject to regulations at the federal or state level is usually a matter of state law. So the answer that I think is what people are looking for with that first question is my business a small business? And the answer to that would be assess your number of employees that you have that are full-time employees, and then check your state's regulation for the size that's required. It may even be on a per law by per law basis. The legislatures and by extension the agencies, they do have the power to make those determinations in terms of how the law applies. As we discussed today, there's a trend going on where perhaps the federal government for federal laws considers a larger number, usually 50 or more, but the smaller state governments below the federal government are making a lot of these laws applicable to much smaller businesses with smaller numbers of people. So the small business is more of a colloquial term, kind of like Small Business Saturday after Thanksgiving. You want to go out there and shop at the local hardware store, but the small business from a legal sense, it's really on a case-by-case basis. As far as the employers, do they have to give 40 hours of sick leave immediately after hire? As we discussed today, there's certain states that require certain amounts of sick leave. California has laws like that in place now that are relatively new. States that don't have those laws, it can be after 90 days. The sick leave that's required is only going to be required if your specific state has that set up in their legislation or rules. Otherwise, 90 days traditionally considered to be probationary periods. Those can exist before time is provided. As a general rule, as something to just think about more broadly, what we're talking about sick leave, we're talking about paid compensatory time. I think that's what most employers are kind of thinking in the background. Do I have to pay people to be off? That's fine. You may not have to necessarily do that if you're not in a state that has a certain time frame set up for that. But what you don't want to do is you don't want to really deny employees time off if it's a reasonable request, even if it's within the 90 days. So if they are actually sick, certainly don't make them come to work because that could be, that could be bad for everybody. But also it can lead to other kinds of things. There's other kinds of requests people might make, like a religious accommodation or a bereavement, like we talked about. And this concept of denying that to them because during the probationary period, they have to work the first 90 days to prove themselves. Things really occur in all situations, and you wouldn't want an employee to bring a lawsuit because they were denied something. What it would turn on was whether or not they had a right to be paid. You certainly can allow an employee within the 90 days to take a necessary time off for something, not unreasonable, not over long, but necessary time off for an emergency that comes up. The difference is that if it doesn't say so in the law or your employment contract, you just don't have to pay for the time. So that would be unpaid time as opposed to paid time.
All right, thanks, Jeff. And again, if you have any more specifics, go ahead and submit them. We'll get them answered later. Let's get another question on the board here. We have time for a few more. What are the current or upcoming leaves of absence and paid sick leave laws in New York? Are there any changes?
I'm not aware of that one. We might have to get back on that question. We talked about in New York a lot of employee favoring protections, but I'm not aware. A lot of the sick leave things we talked about today are really in California. I'd like to get back to that question, I think, for the caller who asked it, because I'd like to look a little bit deeper into the new laws and see specifically how they relate to that topic. So if they could stand by with us, we'll get them a written answer and it'll benefit the whole group.
Sounds good. Those will be emailed to your registration email. So we'll get that to our guests. We'll get another question on the board then. If a person is continuously scheduled for less than 8 hours in California, like 5.5 hours, does 5 days of sick leave encompass 5.5 hour days or up to 40 hours total, regardless of how long shifts are typically scheduled?
I'm a little confused on the math. Let me see if I can try to get that right answer there. That's a pretty specific mathematical question. I don't want to say twice in a row, come back to it, because I know we have a lot of listeners in New York and California. In California, as we discussed today and in the presentation, sick leave is required now, certain amounts of it, up to 40 hours for people coming into the job. And that's a new law that puts, so California, unlike some of the other jurisdictions, is one of the ones that requires mandatory sick leave. Let me just think for a second here and go back. But I think the 5.5 hours, I think what the caller is asking is, they're asking if it doesn't fit as a full day, perhaps, but I think if the employment is full-time employment, it's safe to say that the California laws we discussed today do apply in terms of sick leave. So the question is whether or not the employment is full-time or not. Certainly there's things like alternative employment agreements that allow shift workers to work different kinds of breakdowns. But California has more specific and more strict laws in terms of overtime, which by extension also leads to more strict times laws in terms of how California calculates work weeks and work days. Basically, the federal and California rule is anything within a 7-day period within a defined 24-hour periods that are consecutive. So for instance, a work week doesn't have to begin on a Sunday, it can begin on a Monday, but then it's calculated as 7 comprehensive days, Monday to Monday, Sunday at 6 p.m. to the next Sunday at 6 p.m. or Monday in the same situation and forward. If the person works 40 hours within that period, no matter how you get there, no matter what combination of shifts, then these new laws in California that require certain amounts of sick and paid sick time would in fact apply. So I'm comfortable with that answer, even with the math. I think the question is if shifts run for different times in different amounts, but the answer to that question is in terms of this calculation for the sick leave, it's the 40-hour per week calculation that qualifies somebody as full-time and protected by these laws.
All right, thanks, Jeff. Let's get one more question up on here before we do our recap and tips to go away with. All right, so how will the new defining exemptions rule affect some of those under Section 13A1 of the FLSA that provides an exemption from both minimum wage and overtime pay for employees employed as bona fide executive, administration, professional, and outside sales employees? Section 13A1.
That's a fine question with some very specific statutory sites, but I can
Yeah.
I can speak about it more generally in that what it's going to do is it's going to bring more people into the classification of non-exempt. So these things that are here before, the bona fide is a legal term that comes up for like real world, real time, real talk. Bona fide means it's a real thing and can be demonstrated. Executive, administrative, professional, outside sales, and yes, computer employees. Great catch by the caller who put together that question. Yes, computer employees who fit into those administrative, professional, white collar, pink collar type jobs, they would fit into that. There is language for that. That is a large sector of the population. This new rule that's coming out, when and if it does come out, is going to bring more people into the protections of non-exempt status. So one thing we talked about was an increasing salary will now be brought in because it's going to slide on a scale and it's going to encompass more of those people, but also it's going to encompass more people who perhaps because they had certain kinds of jobs before that classified them out, it's going to classify them in. The government is trending at the current time towards protection of greater numbers of workers, and the law under the FLSA and how they define these categories is expected to move in a direction that includes more employees in the protection. So when you specifically ask to the caller about minimum wage and overtime, it's going to mean that more workers in those sectors are going to be eligible for minimum wage requirements and for overtime requirements as well. Expect the FLSA to get broader and expect to perhaps go in and look a little bit more for some classification of things. That's the trend that we're heading towards, and if this rule gets passed, that's what the workforce is likely to see.
All right, thanks, Jeff. So unfortunately, we've run out of time on our Q&A, but all unanswered questions will be forwarded to Jeff via email, and his responses will be sent to attendees in the coming days. Thanks to everyone who submitted their questions for today's session. Of course, thanks to Jeff for taking the time to answer them. And I'd like to remind all attendees that you have access to that 2024 New Year, New Laws white paper, along with today's slide presentation and the 2024 minimum wage map, which are attached out as handouts here in GoToWebinar. Jeff, can you please leave us with any key takeaways on the labor and employment laws that we discussed today?
Yes, Stephanie, and thank you for today. Thank you to everybody who listened to me for an hour. Thank you to Personnel Concepts and yourself, Stephanie, for letting me do this. I really enjoyed it. I'll give you a couple takeaways. We're getting down to the wire. I don't want to lose anybody. I'm going to number them just because it's easier to follow what I say. So here's a few things I want people to take away from today. as the highlights. Number one, excuse me, be aware of the federal, state, and local laws that affect your specific workplace. For clarification on what your specific business needs to comply with, contact your legal representatives or talk to Personnel Concepts, because they have access to all this information, not just me talking, but in one comprehensive place. Review your employee handbooks and policies and eliminate all references to non-disclosure and non-disparagement clauses whenever they relate exclude out disputes that have to do with sexual assault or sexual harassment. Those will no longer pass muster with the law. Also note that the Federal Speak Act has made those clauses unenforceable, and many states already prohibit such actions. Number three, state leaves of absence and paid sick leave laws are being created and updated more and more frequently as time goes on. Please make sure that your company policies comply with these new and updated rules. Number four, the proposed overtime exemption rule is expected to be finalized during the first half of 2024. Before that goes into effect, however, employers can and should examine the proposed salary threshold to plan ahead for their own budgeting reasons and operational reasons when it comes to reviews, raises, bonuses, salaries, and hiring information. Employers should also review the latest worker classification final rule to determine if affected employees are classified correctly before we get to March's effective date. Finally, number five, recently the Supreme Court's ruling on religious accommodations may mean that your company's policy and definition of what an undue burden or undue hardship is needs to be updated to include more. Examine your current handbook and policies to make sure that your business is in line with the U.S. Supreme Court's decision.
All right, thanks, Jeff, for those takeaways. And before we end today's session, I just want to remind everyone that all attendees will receive a follow-up email with certificate as proof of attendance to today's webinar, along with a recording of today's webinar. It should go out tomorrow. So this concludes today's webinar. Thank you for attending our presentation. We hope you found this information helpful in understanding critical employment law updates taking effect in 2024. Thanks again to Jeff for being our guest attorney, and we just look forward to continuing to work with you on future presentations. And if you enjoyed today's webinar, we invite you to view past webinars on demand within Personnel Concepts Digital Workplace Compliance Library. Click the link on the screen, use the login as your email address, or it would be your customer account number. Contact our customer service if you want help logging in. And to all of our attendees, thank you for choosing Personnel Concepts as your provider of workplace compliance solutions, and have a good afternoon, everyone.